land, water, air, or other bailey for the purpose of transmission to the buyer until the buyer or his agent in that behalf takes delivery of them, such carrier or the bailey. Or the second scenario is if the goods are rejected by the buyer and the carrier or other bailey continues in possession of them, even if the seller refuses to receive them back. The law also gives us the situation when the goods are deemed no longer in transit. So, I discussed that if the goods are transit. Right now, we will discuss about um, when goods are deemed in no longer in transit. So, these are the instances. First, first instance is the buyer of his agent obtains delivery of the goods before their arrival at the appointed destination. Uh, Second is after the arrival of the goods at the appointed destination, the carrier or other bailey acknowledges to the buyer or his agent that he holds the goods on his behalf and continues in possession of them as bailey for the buyer of his agent, and it is immaterial the further destination for the goods may have been indicated to the and finally goods are no longer in transit when the carrier or other bailey wrongfully refuses to deliver the goods of the buyer or his agent. How about if the goods are delivered to a ship, freight train, truck, or airplane chartered by the buyer? It is a question depending on the circumstances of the particular sea, whether they are in the possession of the carrier, such or as agent as a buyer. So now let's say that the seller right to stoppage in transito is exercised. The unpaid seller may exercise his right in stoppage in transito either by A, obtaining actual possession of the goods, and B, giving notice of his claim to the carrier or other bailey in whose possession the goods are. When notice is given, such notice may be given either of the person in actual possession of the goods or to his personal. In the latter case, the note in latter case to be effectual must be given at such time and under such circumstances that the principal, by the exercise of reasonable diligence, may prevent the delivery of the buyer. So after we discussed the possessory lien and the stoppage in transitu, now we will discuss the special remedies or special right to sell goods. Now, this is very important that we take note that the special right of resale is only available if the seller is either have right to possessory lien or still has the right stoppage in transitu, just like what we've discussed earlier, or have been exercised it. Because if it doesn't have either of those two, then there is no special right of resale, notwithstanding that the ownership in the goods may have passed to the buyer. The unpaid seller has a special right, but only under the conditions provided by law. So now, a special right of sale can be exercised under any of the following circumstances. So, first, the goods are of perishable nature, and second, when the reseller has been expressly reserved in case of the buyer should make default, or third, where the buyer has been in default in the payment of the price on a reasonable time. And then maybe you're asking, what is the nature of the sale? It can be either private or it can be public sale. The seller not obligated to give notice of his intention to resell the goods or um, of the time that the place of the sale is not affect the validity of the sale. However, such giving or failure to give notice will be necessary to determine if indeed the buyer was in default for unreasonable amount of time. We will also discuss the effect of having exercised right of resale. When the unpaid sale has exercised his right of resale, he shall not thereafter be liable to the original buyer upon the sale or for any profit made by such sale. but may recover from the buyer damages for any losses occasioned by the breach of sale. So we are now move on to the special right to rescind. We are done explaining or discussing about the possessory in liens, post stoppage in transitu, special right to resale, and lastly, we will discuss about the special right to rescind. That is for lastly, was a special right to rescind. The special right to rescind is similar to the right of sale. Also, it requires that the sellers still have either the possessory lien on the right of stoppage, right for stoppage in transitu, or exercise already the special right of uh, stoppage in transitu, the situation in which the special right to rescind are available to as follows. So, first, that the seller has expressly reserved the right to do so in case that the buyer should make default. And second, the buyer has been default in the payment for the price in a reasonable time. So, maybe you're asking also, what are the effects of exercising those rights, which is to rescind? So the seller shall not thereafter be liable to the buyer upon the sale, but he may recover from the buyer damages for any loss occasioned by the breach of contract. So lastly, the transfer of title. The transfer of title shall not be held to have been receded by an unpaid seller until he has manifested by notice to the buyer or by some other overt act an intention to rescind. It is not necessary that such overt act should be communicated to the buyer, but the giving or failure to give notice to the buyer of the intention to rescind should be relevant in any issue involving the question whether or not the buyer had been in default for an unreasonable time before the right of the rescission was asserted. And after we discuss the rights and the remedies of the seller, we will now discuss the rights and remedies of the buyer in case of breach of a contract of sale. So let's talk about the right and remedies of the buyer in general. These rules also applies whether or not the property is immovable or real property, or the property is movable or personal property. First, the buyer is entitled to receive complete delivery. In other words, the buyer is not bound to accept the delivery in installment unless, of course, the delivery has agreed to be was also agreed upon the party is to be done in installment. If there is no stipulation, then the buyer is entitled to complete the delivery. Second, so that that's the first one. And second, the buyer has the right to examine the goods in order to determine whether the goods are conformity with the contract. The right, it is also the right is subject to that exemption. First, if by stipulation the parties say that there is no right to examine, then that's the stipulation. So that the stipulation will govern. Second is the COD sales or collect on delivery. There's also no right to examination to that case. So there is also an exemption to that. Third is the acceptance by the buyer of the goods or thing will not discharge the seller from his breach or promise or warranty. In this case, the buyer, of course, has to give notice to the seller of the breach as soon as it is on a reasonable time from that and also from the time of the acquisition of the breach. And fourth is the buyer cannot refuse to accept a wrongful quantity of goods. And finally, the buyer has right on remedy and suspension of payment. So when you say suspension of payment, under Article 1590 of the Civil Code, should the buyer be disturbed in the possession or ownership of the thing acquired or should have reasonable grounds to fear such disturbance by a vindicatory action of a foreclosure mortgage. The buyer may suspend the payment of the price until the seller has caused the disturbance or danger to cease, unless the seller gives a security for the return of the price in a proper case, or it has been stipulated that notwithstanding any such contingency, the buyer should be bound to make payment. And again, mere act of trespass shall not authorize the suspension of the payment of the price. Now, the right to suspend of the payment is not available in the following cases. So there are 5 cases that it is not available to right to suspend the payment. So first, if the seller gives security for the return of the price. Second, if there is stipulation, if the parties agree that the buyer will still not pay, even if there is disturbance, there is a danger of his ownership or possession. And third, if the seller was able to make a disturbance on the danger of the disturbance of the disturbance ceased or stopped. And fourth, in case of a mere trespass. And lastly, in the case when the buyer has already paid the price in full. So we are done discussing the remedies in of the buyer in case of immovable property. So right now we will discuss about the special rules in immovable. First, when it comes to a subdivision, properties situated in place, condominiums or condominium units, the law tells us in case that the seller fails to develop the property, the real property according to the agreed upon plans or within the time limit, then the buyer can suspend payment. The buyer can stop paying if the seller does not develop the property according to the plans and or within the time limit. Furthermore, when within the time limit, furthermore, there is any installment payment made by the buyer shall not be forfeited by the seller in favor of the seller in case. Speaking on condominium units, or subdivisions or any other real properties in case the sale thereof in installment, it is governing the governing law of it is Maceda law or Republic Act 6552, um just like what I've mentioned earlier. So Republic Act 6552, entitled the Realty Installment Buyer Protection Act, also what we call the Maceda law, provides for certain protection to particular buyer of a real estate payable in installments. The law declares as a public policy to protect buyers or real estates on installments payments against onerous and oppressive conditions. So the role of Maceda law, it would seem that more than just providing for a substantial and procedural setting for the rescission and cancellation of contract covered therein. The Maceda law in whole is relied upon the use by the courts, including the Supreme Court, as a policy statement of the state in protecting the interest of buyers of or residential or real estate in installments. So there are rights granted to a buyer on a real estate in a sale or financing covered by Maceda law. It depends also on whether or not he has paid less than or more than 2 years of installment. It also exercise of a grace period. The right make use of the grace period can be exercised by buyer only once in every 5 years of the life of the contract, and its extension, if any. Down payments, deposits, or options on the contract should be included in the computation of the total number of installments made. So those are the rules in immovable properties based on the remedies of a buyer. So let's move on to the rights and the remedies of the buyer in case of a movable property. We discussed we discussed earlier the suspension of payment, and those rules also applied here in the movable property. Of course, the next remedy is the right to ask for specific performance or fulfillment of the contract in the case the seller has failed to deliver the thing. The buyer